Okay, let's get started. Good morning. There are some things in life that you do not want to have to use, but you're happy when they are there when you need them. For example, a first aid kit. It's getting chillier out these days. Our cars get harder to start. Jumper cables, good to have. You don't necessarily want to use them, but it's good to have them when you need them. How about a fire extinguisher? That could come in handy, especially the way that I usually try to cook. And EpiPen, many of us have allergies, and EpiPen can be not just something that's nice to have, but something that is a matter of life and death. And of course, as some of us get closer to 50, I'm still a few years away, we think about things like this. It's not something that we relish, but something that it's nice to have when you need it. And finally, it is good to have, next slide please, litigators. And these are some famous litigators. It's always good to have litigators. My name is Max Perlman. I'm one of HRW's litigators. And we get a bad reputation. Some would say that we're the scariest or meanest kind of lawyers. Some would try to blame lawyers' reputations on litigators, the bad reputations that our industry sometimes has. And I'll tell you that most litigators I know take some pride in that reputation. But let me just say that you can faithfully follow the amazing, excellent, intelligent advice that you get from our counselors like Jeff and Pete and Kathy and Charlotte and others. But there is very likely a time that you're going to come to need us. And Pete Moser says it best with respect to his litigators like me. So we keep them behind glass and we break glass in case of emergency. So that there we are. We sit there, we have ties and suits, unlike some of the counselors don't dress up to go to court. We're sitting there behind glass, we're ready to emerge whenever needed. So when are you going to need us? Next slide, please. When you're sued by an employee. And the kinds of cases that we see, and my colleague Sam Gates and I are going to talk about the kinds of cases that we see and the trends. We see discrimination cases. We see sexual harassment cases. And a huge part of our practice now is defending employers in wage and hour cases, cases for overtime, cases under the Wage Act, cases for independent contractor misclassification. So if you're sued by an employee, you're going to need someone like me to defend the company. You'll also need a litigator if you have an employee who walks out the door and violates a non-compete or takes some trade secrets or starts soliciting employees, notwithstanding a valid non-solicitation agreement. So these are the kinds of things that you're going to need for a litigator for. So most roundtables, I presume that most people here on this call have been to many roundtables, and usually the topic of those roundtables is to prevent claims. And I think that HRW does an amazing job in preventing claims, almost to the extent that it seems like they're going to put us litigators out of business. But this roundtable is going to be a little different. We're going to talk about winning the claims. What is it that we have to do to win them? Not prevent them. Prevent them is good, but we'll talk a little bit about prevention. I think that there's some overlap. But we're going to talk about what can we do now, and what can we do once a case is filed to win it. So let's talk really quick about the agenda, and then we'll jump right in. So help me help you. Kathleen Burney and I. Kathleen went to the Tisch School at NYU, so we're going to use her acting chops today. We're going to show you what it looks like in a court case if you don't do things correctly. Then I'm going to talk about my playbook for reacting to a lawsuit. Talk about what you do on the first day, the first week, the first month. Sam Gates is going to talk about the new world of potential COVID claims, employment-related COVID claims that may come down the pike. He's also going to talk about trends in discrimination and wage claims. Then I'm going to take back over. I'll talk a little bit about class actions, and then finish with talking about trends in non-compete and trade secrets cases. That's a big part of my practice, is dealing with those restrictive covenants. And then hopefully, if we have time, we'll take some questions. Next slide, please. So we can preach to you all we want. We can have as many roundtables, we can have as many counseling sessions, and we can tell you what the right thing to do is. But sometimes it's good to see where the rubber meets the road. And the reason is, and let's go to the next slide, you're going to be the one on the stand. There are many people on this roundtable, attendees of this roundtable, who are going to be on the front line. You're going to be on the stand if the company is ever sued. You could be cross-examined in court about the adequacy of the company's policies and practices. And I got to be frank with you, it's scary. It's not a fun endeavor, just like the doctor with the glove. It's just not something that anybody's really going to enjoy. And I'm going to show you what this might look like. So with the help of our decorated actress, Kathleen Burney, we're going to go through 4 cross-examination vignettes. And it's in the fictional case of Angie Schuyler versus Hamilton Inc. And Ms. Schuyler is a former employee of Hamilton Inc. and she has been terminated by the company. And she has sued the company for discrimination and harassment. So let's prepare our courtroom. Aaron Larson, can you just confirm to me that we've got the split screen? So maybe I'll change my background to something that looks like a courtroom. There, okay. All right, are we split screen, Aaron? You can text me and let me know just so it's good. Okay, we're good. Okay, so here is vignette number 1. And these vignettes, we're gonna show you one where things didn't go very well. And then the second vignette for each of these 4 topics is going to be what you might expect if you've gone through and done everything correctly. So let's get started. Again, this is I'm cross-examining the fictitious VP of HR of Hamilton Inc. Her name is Erin Burr, E-R-I-N-N, just like Aaron Larson. And again, this is litigation regarding former employee Angie Schuyler. Okay, and let's get started. Ms. Burr, Hamilton Inc. cares about preventing sexual harassment in the workplace. Is that correct?
Well, of course.
It's important to Hamilton that no employee is sexually harassed. Isn't that right?
Yes.
Okay, so of course, given the importance of this issue, Hamilton takes all necessary steps to make sure that no one is harassed.
Of course.
And one of the steps that it takes is it communicates to employees what they're expected to do to prevent harassment.
Yes.
How does it do that?
Well, we publish a sexual harassment policy.
Huh, a policy?
Yes, a written policy.
Okay, so all the employees get a piece of paper that tells them what they have to do to prevent harassment. That's what you're telling me, right?
Yes.
Anything else?
What do you mean?
Well, do you train your employees on sexual harassment?
Train?
Yeah, do you train them?
I think, yes, I think we have in the past.
Okay, so when? When did you last train?
It was a few years ago before I came to the company.
Okay, so so no training for at least a few years.
Right.
Despite the importance of this issue.
I guess.
Now, do you know Jim Madison, the former manager of Hamilton Inc., accused in this case of sexually harassing my client, Angie Schuyler?
Yes, I do.
Do you know whether he received sexual harassment training?
Yes, I think he would have.
Okay, Ms. Burr, I am not interested in whether he would have. I want to know whether he did. Can you tell me one way or the other whether Mr. Madison received sexual harassment training?
No.
Okay, so I presume by your answer, you could not tell me the content of any sexual harassment training that Mr. Madison may have received.
I'm afraid that's right.
Okay, so let me see if I can summarize then, Ms. Burr. So despite the importance of the issue of sexual harassment, Hamilton does not regularly train its employees on sexual harassment, can't even tell me whether Mr. Madison received any training or what the contents of the training were. Do I have that right? The answer is yes, right? What did I miss?
Yes.
Okay. All right. And scene. That was uncomfortable, wasn't it, Kathleen?
It sure was.
You wouldn't want to sit next to one of our clients when they had to go through that. So that emphasizes why it's important to have proper training. So let's go through the same scenario where the client actually did the proper thing, the right training. And it starts off the same. Ms. Burr, Hamilton Inc. cares about preventing sexual harassment in the workplace, right?
Of course. Of course.
And it's important to Hamilton Inc. that no employee is sexually harassed, right?
Yes.
So, of course, given the importance of this issue, Hamilton Inc. takes all the necessary steps to make sure that no one is harassed. Isn't that right?
Yep. Yes.
Okay. And one of the steps it takes is to communicate to employees what they're expected to do to prevent harassment, right?
Yes.
How does it do that?
Well, first of all, we have a sexual harassment policy.
Oh, a policy. Wow.
Yes, a written policy.
Oh, okay. So all the employees get a piece of paper that tells them what they have to do to prevent harassment, right?
Yes.
That's what you're telling me? Okay. Anything else?
Yes, while we regularly train our employees, every employee must participate in a 2-hour training module regarding preventing sexual harassment.
Yeah, but how often does that have to happen?
Well, actually, we hold the training yearly. All new employees must attend a session during their first year, and we require a refresher for every other employee every 2 years.
Yeah, but do you know that Mr. Madison, the manager accused in this case of sexually harassing the plaintiff, do you know him?
Yes, I know him.
Do you know, how do you know that he was trained?
Well, I know he was in the room when it happened in our Yorktown office. Plus, we have documentation of the training. He signed and he dated acknowledgments stating that he had participated in the sexual harassment training session each of the years that he worked for the company.
Are you, no further questions. All right, and scene. So we can all see how much better it went for Ms. Burr when she was able to talk about not only the fact that the training happened, but that she was able to prove that the training happened. So this, I think, is a lesson. When you're doing training is a great thing to do on its own. If the only thing that you're accomplishing by doing training is by trying to eradicate harassment and discrimination in the workplace, that's great. But the extra step is to do it in a manner that permits someone like me to use that training as evidence in a lawsuit, evidence that the company is conscientious, evidence that the person who's being accused of harassment actually was told by the company the correct way to behave, and that enabling the litigators to prove that the behavior of the employee, the manager, is outside the range of what the company expects and communicates. So the first, and we can go to the next slide. I think we'll go. There we go. So boom, one more. Okay, so that was our first vignette. Have you trained your employees? We can go to the next slide. So here are the things you can do. So the first thing you can do to help us win suits by employees: have effective policies. Make sure your policies are ones that you can testify about, and then training as well. So we can go to our second vignette. This is a very important one. Have you documented performance issues? And Ms. Larson, would you please prepare the courtroom again? Let me know when it's get ready. Okay. All right. And again, I'm continuing to examine Ms. Erin Burr, VP of HR at Hamilton. And my first question. Ms. Burr, do you maintain the company's personnel files?
Yes, I do.
Okay. And the company is required by law to maintain these files, right?
Yeah, that is my understanding.
Okay. And the law requires the company retain a complete copy of the personnel record of its employees, including documents that affect or are relative to the employee's qualifications for employment, promotion, transfer, additional compensation, or disciplinary action. That's what the law says, right?
That is right.
So, do you know my client, Angie Schuyler? Do you know her?
Oh, yes. Yes.
Okay. And why was Ms. Schuyler's why was her employment terminated? Can you tell me?
She was a very poor performer.
Okay. Well, I'm handing you Ms. Schuyler's personnel file, and I want you to take a look through it. Can you show me a document, any document in this file, that indicates that she was a poor performer, as you say? So go ahead and take a look.
Oh, yeah, sure. Well, here is a memo that talks all about her poor performance.
Okay, this memo right here that you just handed me?
Yes.
Can you please tell the jury the date of the memo that you just handed me?
January 30th, 2013.
Okay, and the date of termination was?
January 31st, 2013.
Okay, so the next day. You terminated the day after that memo. And in the 5.5 years before the January 30th, 2013 memo, is there a single document in your file that you're required to maintain by law that evidences Ms. Schuyler's poor performance?
Not that I can find.
Take your time, take your time. No, okay. No, there is no such document. No such document. In fact, there are documents in this personnel file that show that she was not a performer at all, aren't there?
What do you mean?
Well, let's do it this way. Does Hamilton have an employee review process?
Yes.
And the process is supposed to give the employees an honest and accurate assessment of their performance, right?
Well,
Hamilton doesn't want to give a dishonest or inaccurate assessment, does it?
I'll have to say a no to this.
Okay. So the process is supposed to give the employees an honest and accurate assessment of their performance, right? We can agree on that?
Okay, sure.
All right. And this process guides the company making important decisions regarding compensation and promotion, right?
Yes.
Okay, so to recap, the performance appraisal process is important and it is honest and accurate, correct?
Yes.
Back to the performance appraisals. Reviewing those appraisals in your file for Ms. Schuyler, do you see that all the marks received by her during the 5.5 years that she worked for the company were either satisfactory or higher?
Yes.
And this was an honest and accurate appraisal of her performance, right? Ms. Burr, one last time. And this was an honest and accurate appraisal of her performance, right?
Right.
Okay, and scene. So the company had some trouble. The company thought she was a poor performer, but as my colleague Jim Wellicke, who is a plaintiff side lawyer, calls this phenomenon, oh my God, we just realized how terrible an employee you are. And that's a red flag to plaintiffs lawyers everywhere. So we don't want to do that. We've got a short vignette about what happens if you do this correctly. Ms. Burr, why was Ms. Schuyler's employment terminated?
She was a poor performer.
What evidence does the company have that she was a poor performer?
Well, as is set forth in her detailed personnel file, which you have, Ms. Schuyler received negative evaluations in the last 3 years of employment. On 5 occasions in the past 2 years, she received written warnings regarding her employment. Each of these warnings became increasingly severe and indicated that if she did not improve her performance as requested by the company to the point where the company was satisfied, Ms. Schuyler would be terminated. Ms. Schuyler signed and acknowledged the evaluations, but she never improved her performance. In fact, in 2018, she was caught at her desk drinking. She tried to hide it, but we looked in her garbage can and she had thrown away a shot. All of this was addressed in the September 2018 memo by her former supervisor, Jim Madison. Finally, the week before her separation, she failed to turn in a project on time, as is indicated in the memo by her current manager, Tom Jefferson, who was Mr. Madison's right-hand man. Do you want more?
Never mind. That would be enough. And scene. Okay. So why does this happen? Why is it? And it's very possible that Ms. Schuyler was a poor performer. And I've seen plenty of cases where the employee in question is a poor performer, but the evidence suggests otherwise. And so I boil it down to conflict avoidance. And I think a lot of the times managers are inclined to give employees the 3 out of the 5 instead of the 2 they deserve or the 4, because it's human nature to want to avoid conflict. The person has to go in and work with the person. They've just given the 2 out of 5 on their evaluation. In your materials, there's an article I wrote a number of years ago concerning the value of avoiding conflict avoidance and how we have to train our managers to make sure that they're brutally honest when they're evaluating their subordinates, and in particular, how much impact it could have on a manager's ability to perform and to have their department perform if they don't do just that. Okay, so let's go to another vignette. Maybe go to the next slide so we can just finish that point. Maybe I'm not. Okay, well, let's just go to the next vignette. I think we've covered the content. Oh, looks like we are. Okay, so go ahead. Next slide, please. All right, so documentation of performance issues, and just a larger point on documents. It's very helpful for the litigators to have documentation of performance. It's also really helpful for us to have super clean agreements. And I think one small tip I would say is we handle a lot of cases concerning sales commissions, and they're very high stakes because the statute provides for multiple damages, 3 times damages. So one thing I would highly recommend is that everyone on this call, if you're in an organization that uses sales commissions and a sales commission plan, ask to look at it today. If it looks like a legal document, then you might be on the right path. If it looks like it was sketched out by the VP of sales, then you might want to pay some more attention to it. So that's just a kind of a side note. One of the real things that I crave in these the commission cases is a really cleanly written document. Okay, so let's go now to a vignette concerning preservation of documents. So parties have a legal obligation to preserve documentation that is relevant to reasonably anticipated litigation. So let's continue the examination of Ms. Burr. Okay, Ms. Burr, did Ms. Schuyler's boss, Mr. Madison, email anyone regarding the reasons for my client's termination?
I do not know.
Well, has a company searched Mr. Madison's emails to find out?
Yes, but we only have emails from Mr. Madison going back 2 months to the beginning of January.
Well, can you tell me what happened to the earlier emails in Mr. Madison's account?
Yes, they were overwritten by the company's automatic deletion program. That goes back 2 months.
Okay.
Gets rid of emails that are more than 2 months old, that is.
I see. Well, are you aware the company has had an obligation to preserve documents for this case as soon as litigation is reasonably anticipated?
I recently learned that.
And my client sent you a letter on September 1st, 2019 that threatened litigation?
Right.
So as of September 1st, 2019, Hamilton Inc. reasonably anticipated litigation with my client, right?
I suppose so.
So what did the company do to fulfill its obligation to preserve documents at that time?
Nothing.
Okay, and it was after my client's letter that Mr. Madison's emails were overwritten and deleted, right?
Right.
So the company could have preserved these emails when it learned of the possibility of litigation, right?
Yes.
But it didn't, did it?
Can I take a break?
No, please answer my question.
Okay. You're right, it didn't.
And because of the company's failure to preserve evidence, we'll never be able to see what Mr. Madison was saying about the reasons for my client's termination.
Right.
In fact, emails that prove the discriminatory intent of Mr. Madison and Hamilton Inc., emails this jury will never have the chance to see, might have been lost due to the company's failure to meet its legal obligation to preserve evidence?
Uh,
Can you answer my question, please? And scene. Believe it or not, that scene was based on an actual deposition that I took a number of years ago. The relevant pages of the transcript will be in your materials. And the witness who was responsible for not having preserved documents for a large company that should have known better actually had a panic attack, passed out, and had to be taken out in a stretcher. I don't want anyone on this call to ever feel that level of stress at a deposition. So please, right at the outset of a case, make sure you preserve documents. It's very, very dicey when you do that. You can lose a case. You can lose a case just because you didn't preserve the documents. Maybe you have the very, very best defenses, you're the best of intentions, everything is going your way, but you didn't preserve documents, and that could be a deciding factor in these cases, which gives people like Ms. Burr a great deal of stress, as you can see by the fact that she just passed out. Okay, so as we wait for the bad Ms. Burr to be taken to the hospital, let's talk about, let's do the vignette where things went a little bit better for Hamilton Inc. So if we can get back, okay, there we go. All right. So Ms. Burr, did Ms. Schuyler's boss, Mr. Madison, email anyone regarding the reasons for my client's termination?
no,
Well, I understand the company has an automatic deletion program, which gets rid of emails that are more than 2 months old. So Mr. Madison's emails that are more than 2 months old are gone, right?
no,
Why not?
because as soon as we received your client's letter on September 1, 2019, threatening litigation, my office sent a document preservation notice to the various peoples and departments at the company that would have had information to preserve. Among other things, the notice specifically requested that the IT department suspend all deletions of Mr. Madison's email. And we took and made a copy of Mr. Madison's email account. So as soon as we knew that litigation was a possibility, we made sure that we took appropriate steps to save documents and evidence.
Okay, moving on. Okay, and C. So you can see how much easier it is, and Ms. Burr gets to stay upright and not be transported to seek medical attention when she does things correctly. So to the next slide, Aaron. There we go. So the third, so we've gone through a vignette about effective policies and training, documentation of performance issues, and the third thing that I want you to do to give me a tool that's going to help me win your lawsuit is take prompt preservation efforts. Let's not even leave a question as to what the company did with respect to documentation. Let us use all the evidence that we have without the argument that we shouldn't be able to use that evidence because other evidence has been thrown away or deleted. And sometimes this involves not just the admonishing against active deletion, but as is mentioned in the vignette, there are automatic deletion programs that companies have concerning emails. It only keeps emails for a certain amount of time. You want to make sure that that is disabled. So, okay, on to our final vignette. Have you protected your trade secrets? So this has to do, this is a slightly different case. So the first three vignettes dealt with a discrimination matter brought by Ms. Schuyler against the company. This is a little bit different. This is going to be a case by Hamilton Inc. against Ms. Schuyler for allegedly taking trade secret information. Okay. Kathleen, are you with me?
I am.
Okay, good. All right. So, Ms. Burr, you claim that my client, Angie Schuyler, stole the company's confidential information.
Yes.
What information?
Hamilton Inc.'s customer list.
Is that information that the company keeps confidential?
Yes, it's our lifeblood.
So I presume the customer list is very valuable to Hamilton?
Enormously.
And it's important to the company that it remain confidential?
Oh, yes. We cannot have our competitors know who our customers are. I mean, they would go out and steal our business and we would be helpless.
Got it. So what steps does a company take to protect the customer list?
What do you mean?
Well, this document that you call the company's lifeblood, what steps do you take to ensure its confidentiality?
Well, it's understood that it's confidential.
Understood, but by whom?
We just all know, that it's confidential.
Okay. Is this understanding that you're testifying about, is it documented any place?
No, but we all just know. It's obvious, it's confidential.
Okay. The company protects its life. So just to recap, the company protects its lifeblood through some undocumented, understanding.
I guess, but you're totally twisting my words.
Okay, well, let's see if we can get this a little clearer then. I'm showing you a printout that I made of the Hamilton Inc. website, available for anyone with an internet connection to see, and in particular, the page entitled Customers. Can you please tell the jury what this is?
Well, I mean, it's a list.
Oh, it's a list. Okay, it's a list of what?
It's a list of our customers.
Okay, so and seen. So this illustrates the need for companies, if they're going to claim that information is confidential, is valuable, to take steps to protect it. Now, it seems crazy that you would be able to find confidential information on folks' websites, but it's happened so many times where a company will race in to get an injunction and claim things that are confidential, and then you just look on the website and there it is. And this often has to do with customers. Companies will say, these customers and our relationships with these customers and the fact that we service these customers is confidential, but then there's a list or there's a slide deck that gets distributed at a trade show or some other thing. So the lesson here is to make sure that you're taking steps, actual steps, documented steps to protect the information that you consider to be confidential, and to make sure that the outward facing, the public face of the company is not sharing this information. There's nothing on the website. There's nothing being published at trade shows or conferences. Okay, so let's talk about, let's do a vignette where Ms. Burr has a little bit better of a chance. Okay, Ms. Burr, you claim that my client, Angie Schuyler, stole the company's confidential information.
Yes.
What information?
Hamilton Inc.'s customer list.
Is that information the company keeps confidential?
Oh, yes. It's our lifeblood.
So I presume the customer list is very valuable to Hamilton?
Enormously.
Is it important that the company that it remain confidential?
Yes. We cannot have our competitors know who our customers are. They would go out and steal our business.
Got it. So what steps does Hamilton Inc. take to protect the customer list?
Well, for starters, we require all employees to sign a confidentiality and non-disclosure agreement.
Is that it?
No, actually. We also have extremely tight security controls on access and distribution, and only certain employees can view the list, and even fewer can print it. When printed, the customer list contains a watermark that reflects that it is absolutely confidential.
Okay. Is that it?
Actually, no. The company also monitors employees' access to the customer list, and I get a notification of any irregular activity in this regard.
Okay. Is that it?
Actually, no. The company has, in fact, sued former employees who managed somehow to steal our customer list and have successfully obtained injunctions requiring the return of our list, just like we're doing here.
Is that, no further questions. And scene. So before we go to the lesson, a little round of applause for our actress, Ms. Burr, played by Kathleen Burney. Thank you very much. Great job.
Thank you.
So you see through that vignette the steps that a company might take to protect confidential information, right? Certain monitoring software, having agreements in place, actually enforcing the agreements when it becomes necessary to do so. If you take those steps and others, you'll give your witness a good chance to defend its claim, or to make its claim that the information is confidential. So let me talk about some other tools that help us win non-compete cases. And these tips apply to confidentiality or trade secret claims and non-compete cases for the most part. So you can help us get a preliminary injunction preventing the employee from working at a competitor, or preventing the employee from disclosing trade secrets by having reasonable and custom-tailored agreements. So this has become even more necessary by the enactment of the new non-compete statute, where there are certain requirements that the law puts in place now. I mean, you used to see 2-year non-competes, 3-year non-competes. The statute now says 12 months is all you can get. And I think, excuse me, I think courts often look at how far the employer has reached as an indication as to whether the employer is a good actor or a bad actor. And sometimes that can make all the difference in one of these cases. Another way you can help us get the preliminary injunction is in certain cases, like when there's a salesperson, sometimes a non-solicitation provision is just as valuable as a non-compete. If you can keep a sales employee from soliciting their former customers or the company's customers, that oftentimes will have just as profound an impact as a non-compete. And it's much, much easier to get a court to enforce a non-solicit than it is a non-compete. Adopting a trade secret and confidential information protection program, which I think is illustrated by the vignette, some things you need to do. Court is going to want to know if you're saying that there's information that's confidential, it's going to want to know that you took steps to protect that information. Monitoring tools, always important to be able to look and have the breadcrumbs to see what the employee has done with the information. For example, on Salesforce.com, there are certain tracking functions that you can pay for. They're a little expensive, but you can see everything an employee has done logging in and out of the Salesforce.com system. Your computer should be set up so that in particular employees who have access to trade secrets and confidential information, that there's an ability to monitor what they're doing on those machines. You want to conduct a proper exit interview. You want to ask where the employee is going and remind the employee that they have obligations to the company. And then last but not least, if you do have a concern concerning an employee who is leaving and perhaps taking trade secrets or violating a restrictive covenant, like a non-compete or non-solicit, let us know as soon as possible, because time's of the essence. If you're going to go in and try to prevent the employee from doing some behavior, either competing or using trade secrets, a court wants to know that you're treating that as an emergency, because you're asking the court to grant emergency relief. So the court is most likely to do that if the employer acts in every way as if it's an emergency too. So next slide. We rest our case. That's the end of the vignettes. So to this point, what we've talked about in this roundtable is things that you can do right now in order to enhance your, not to necessarily to prevent lawsuits, although some of the things that we've pointed out will help prevent lawsuits, but things you can do right now to help your litigators, give us a tool to win the case. Now I want to segue to my playbook for reacting and responding to a lawsuit. So what do you do when you're sitting in your office and a process server shows up and puts a summons and complaint on your desk? So what do we do? So let's take a look at what we do on day one. We're going to break it down. Day one, week one, month one. Day one, contact counsel. Get us involved at the beginning. We know what we're doing. We know how to react to a lawsuit. We also know how to avoid the pitfalls of a party who has received a lawsuit and maybe overreacts to it. You're going to want to evaluate whether there are urgent deadlines. So oftentimes the complaint will come with a motion for a temporary restraining order or preliminary injunction. You know that if you receive that, there's going to be immediate action required. But in any event, you should be contacting counsel and letting them evaluate the suit in the papers to see if there's anything that has to be done. You should notify those in the organization who need to know, and that should be done through counsel so that we preserve the attorney-client privilege in those cases. And as part of the materials, there's an article that my partner Scott Roberts wrote a number of years ago about, I think he called it the 5 Ps in responding to a lawsuit. And one of them was panic, don't. So don't panic. I mean, don't go and call opposing counsel, or don't call the plaintiff and chew him or her out. Don't call an emergency board meeting that's not privileged. So the best thing to do is contact counsel and let us kind of drive and quarterback the issue from there. On week 1, just let's move the slide. Okay, you want to formally engage counsel, so we'll have an engagement letter that will define the scope of the representation. We're going to issue that litigation hold memo. Good idea, right? Because we saw Ms. Burr and what happens when you don't do that. You want to see if you've got insurance, whether you have insurance or whether if there's an individual who's sued along with the company. If there's directors and officers insurance coverage, you're going to want to contact the insurer or the broker to start that process as soon as possible. That step might dictate who you can use as counsel, but you're definitely going to want to get the insurer involved very, very early. Number 4, and this is not necessarily legal advice, but something that we often get involved in, is developing an internal PR strategy, talking about what are we going to say to our employees about this case? What are we going to, whatever we're going to say has to have 2 goals. Number 1 is going to be making sure that our employees are okay with what is happening. And that we maintain the goodwill, notwithstanding the fact that we've gotten sued by one of their former colleagues. But the other goal is not to hurt ourselves in the context of the lawsuit, not to say anything that can be used against us in the lawsuit. We're also on week 1 going to want to start to develop our external PR strategy. If I get a call from the Boston Globe or from the Boston Business Journal, we're going to want to know whether we're going to say something, and if we're going to say something, who's going to say it and what's going to be said. So, and this is not every case, but cases, so oftentimes you can smell out the cases that are going to draw attention. You're going to want to make sure that the folks who are involved in responding to the lawsuit understand the attorney-client privilege and that they are not communicating with each other outside the presence of counsel. You're going to want to consider a joint defense if there is an individual involved. You're going to want to consider a joint defense agreement with that person so you can have the privilege cover the company and the individual. And also in week 1, if there is a temporary restraining order or preliminary injunction request, the client's job is going to be to assist in opposing that. So what will you be doing? You'll be giving facts and signing affidavits and enabling the lawyers to fight the attempt to get an injunction. Let's go to what do we do in month 1? So usually the response to a legal complaint is due within about 3 weeks. There's often extensions, but so what you'd be doing in month 1 is helping your lawyers respond to the complaint, and that often means answering the complaint, admitting or denying the allegations that are in the complaint. You don't want to compile relevant documents for your lawyers to look at and review to confirm that the admissions and denials are correct. You want to determine your priorities. Like, is it really important to fight this case? What's at stake here? Does it make sense for us to fight this full steam, or is it going to have some collateral impact on our employee base? Is it going to turn people off? And that also ties into the last bullet there, which is contemplate early. There may be times in the first month where you look at a case and you say, listen, we have no appetite for this. Pre-litigation, they demanded X. Maybe we should try to see what we can do to get it settled for as far from X as we can, but let's get it settled. And then you're going to want to also figure out and contemplate a budget. Litigation is expensive, and it often goes on for years. There are cases that we have in our firm that were started in 2013 and 14. So you're going to want to try to figure out what kind of ability and appetite you have for fighting the fight, and what the budget's going to be for the litigation. Okay, so with that, I think we'll hold questions to the end, but I would pass over to my colleague, Sam Gates, another litigator at HRW, and he's going to talk about anticipating COVID claims. This is something that we did not cover in any 2019 roundtables for good reason. This is a new and an interesting area of law. So Sam, take it away.
Thanks, Max. As Max said, my name's Sam Gates. I work closely with Max and Kathleen and all the other great litigators here at HRW. That's going to be a tough act to follow, but here we go. So talking a little bit about anticipating COVID-related employment law claims. I think it's safe to say that navigating the legal landscape during this pandemic has really often produced more questions than answers. But looking back, I think one thing we've been certain of from day one is that there will be a wave of employment litigation that results from the pandemic. And as a business owner, as Max was just describing, I think it goes without saying that litigation is almost always something you're looking to avoid. It can be costly. It can often be protracted. And I think the reality is, that reality, the litigation reality, is now amplified where businesses are already grappling with reduced revenues and are generally spread pretty thin. So now that we're 9 months or so into this pandemic, how are those anticipated lawsuits taking shape? So a review of various resources puts estimates of COVID-19 related lawsuits nationwide at roughly 1,200 separate lawsuits since March of this year. And the number of lawsuits per month has increased every month pretty reliably, with 228 separate suits filed in October alone. The most common case, not surprisingly, relates to remote working arrangements, and the most impacted industry, again, not surprisingly here, is the healthcare industry. Now, Massachusetts numbers are relatively low, actually, compared to states like California, Florida, New Jersey, but our own practice and our research tells us that the litigation we've seen here to date in the Commonwealth is really just the tip of the iceberg, and especially in the employment space. The volume of litigation we think is only going to trend upward as businesses begin to reopen and employees are called back to work. So where are we seeing claims? This is pretty common sense. We're seeing a lot of claims arising in the food services industry. Again, not surprisingly, a lot of claims in the healthcare services space, and again, in the hospitality and recreation industries. So what about the types of claims? Employees, we're going to see some lawsuits inevitably from employees who allege that they contracted COVID-19 during their employment. Now, these suits could take the shape of workers' comp claims, or they could just be ordinary tort negligence claims. There's a lot of litigators sort of speculating that causation issues, connecting the workspace with contracting COVID-19 could be difficult, and it could make these cases hard to prove. So that they could be something the plaintiff's bar doesn't get too excited about. But relatedly, as businesses begin to reopen, they're going to need to do so in accordance with state and local protocols. We have plenty of those here in Massachusetts, in addition to those issued by the CDC, OSHA, other agencies. So as a result of those protocols, we're likely to see an uptick in government enforcement actions in response to employers that aren't complying with protocols, or where an employee makes a complaint alleging that their employer isn't protecting employee safety. We're also going to see claims stemming from the protections provided by the Families First Coronavirus Response Act. The FFCRA includes a paid sick leave provision, under that provision, employees qualify for paid leave if they're unable to work for certain reasons related to COVID-19. So the first issue here is that employers are likely to face lawsuits for just failing to comply with that provision. But the second is that even if a business is complying to the letter, we could well see lawsuits by employees who are claiming they're retaliated against. So in other words, an employee alleging that some sort of adverse action was taken against them because they took FFCRA leave. And I'm going to discuss this a little bit more later, but we're seeing a general uptick in retaliation-based lawsuits. So that's something to keep an eye on. It's also worth noting that one factor that could drive the volume of lawsuits filed under the FFCRA is that there's no exhaustion of remedies requirement like we see under some other statutes. So in other words, employees can just go straight to court without having to first file a claim with an agency like, for example, the EEOC. So we're also likely to see a big uptick in COVID-19 related wage and hour claims. Wage and hour claims are generally on the rise, and COVID-19 is going to be another factor there. Safe to say that employees should anticipate a significant uptick because of the changed circumstances brought on by the pandemic. I think major disruptions in normal day-to-day business operations and functions are a breeding ground for wage and hour suits. And that's because so much of the art of avoiding a wage and hour claim is tied to consistent record keeping, consistent tracking of how much employees are working, how much they're being paid. And when there's a disruption to those systems, mistakes get made. And I'm going to get into this in a bit more detail during the next topic, but the devil just really is in the details in the world of wage and hour. So a simple calculation error can get even the best intentioned employees in hot water. So some of these wage and hour claims are going to arise in the context of tracking wages. In other words, tracking systems that break down with employees working from home, employers losing track of monitoring hours worked, and that could lead to wage claims. Also keep in mind that, and this is a fairly specific circumstance, but keep in mind that if employees need to purchase equipment that allow them to work from home, and those purchases push them below minimum wage, the employer could be responsible for those costs. Another potential COVID-related wage claim to be aware of could arise out of just the time it takes employees to comply with safety measures when they do return to work. So if you're implementing a COVID safety plan, which you should, and you're requiring employees to temperature check, maybe respond to a questionnaire or clean equipment, for example, that's time they're spending at work, and they need to be properly compensated for that time. Otherwise, you could be asking for a lawsuit. There's also going to continue to be a rise in lawsuits related to layoffs and furloughs. Some of these are going to relate to the Work Adjustment Retraining Notification Act, the WARN Act, which requires employees with 100 or more employees to give certain notice before laying off certain numbers of employees. And if you miss that window, there are back pay requirements. Now, there's also likely to be discrimination and retaliation lawsuits related to layoffs and furloughs, where employees allege that they were only selected for a layoff or a furlough as a pretext for discrimination or in retaliation for protected workplace complaints. So we're almost certain to see lawsuits where employees are alleging that they were targeted for a layoff based on their race, their gender, their age, et cetera, and not for a business reason. Now, there have been cases where employers have been alleged to target parents, mothers and fathers for layoffs because they predicted those employees would be less productive working from home. That's ripe for litigation as well. We're going to see lawsuits based on claims by furloughed employees that they were asked to work during a furloughed period. And that could be something as innocent as just calling an employee that's been furloughed and asking maybe where they kept a file or what a password is. And that could easily trigger a claim based on an allegation that the employee's owed for that time. And we're going to see disability discrimination claims by employees who allege that they're concerned or afraid to return to work because a medical condition makes them more susceptible to COVID-19. And an employer that fails to reasonably accommodate that concern could face a discrimination claim. We saw this recently in the federal court here in Massachusetts, where an employee was suffering from asthma and denied by his employer a request to continue teleworking while other employees in his same position have been called back to work. He filed a discrimination claim, sought a preliminary injunction requiring the company to permit him to continue to telework. And the court actually allowed that motion and enjoined the company so as to require that employee to continue to be able to work while the parties engaged in some discovery to reveal what, some of the background on what amounts to a reasonable accommodation in that situation. So let me, as Max said, we're mostly concerned with telling you what to do when you find yourself in a lawsuit, but as Max did, I think it's important to talk at least a little bit about what you can do to avoid COVID-related litigation. Now, as with all litigation, the unfortunate reality is that even the most conscientious employer can find itself in the crosshairs, but there are best practices to reduce that likelihood and arguably even limit the damage if a lawsuit's filed. Obviously, you want to make sure your policies are up to date. The policies regarding FMLA, PFML, and the FFCRA, among others, your anti-discrimination, your retaliation policies should reflect the latest developments, and we think should be drafted with the help of an attorney who understands those issues. Likewise, it's going to be critical to have a COVID-19 safety plan. Make sure you have those policies in place to document, investigate, respond to any reported concerns from employees. Max covered this extensively, but again, make sure your managers, supervisors, HR professionals are educated about relevant policies and procedures, provide all required notices, make sure you're documenting positive COVID-19 diagnoses, and document all steps you're taking in response to that situation. So I'll just flip briefly to my next topic here, Aaron. Or I suppose there's no slide for the next topic, so you can leave the last one up. So let me just cover briefly here some trends we're seeing in discrimination, harassment, and wage claims. And let me just be clear that what I mean here is not what developments are we seeing in the substantive law in those areas, but rather what kinds of cases are we seeing actually making their way to the courts. And I think the broad theme here, at least from our perspective, is that litigation appears to be trending more towards wage and hour cases and away from discrimination cases. And so, I think it's worth noting that what drives litigation for us, for Max and I and a lot of the litigators here at HRW, is the activity in the plaintiff's bar. So for the most part, we're playing defense. We go where the plaintiff's lawyers take us. So let's think about why it is that the plaintiff's bar appears more interested in wage and hour cases. What's driving them to file those lawsuits over others? First, and this is a little bit of speculation here, but we think it's likely that in 2020 we've potentially reached an era where employers are getting more attuned to discrimination and have policies in place to address it. Now, that's not to say there aren't plenty of bad actors out there still, but we think it's safe to say that employers are learning not to discriminate. On the other hand, the subtleties of independent contractor classification laws, Wage Act exemptions, overtime calculations are still the source of a lot of mistakes that can lead to wage and hour type claims. Second, without going into a long lesson on the law of employment discrimination, let's just say that discriminatory intent can be a pretty difficult thing to prove. There's very rarely a smoking gun out there, a piece of direct evidence that an employer can point to and say, hey, look, it's clear, that an employee could point to and say, hey, look, it's pretty obvious that I was being discriminated against here. Wage cases, on the other hand, tend to be a little bit easier. And that's because, as I was saying, these claims often come down to just proving a mistake or even a clerical error. There's no need to establish slippery things like motive, intent, state of mind. You just need to show that somebody did some bad math. So you combine both of those factors with strict liability standards, plus the availability of multiple damages under the Wage Act, and the damages associated with these cases can get really big in a hurry. And Wage Act claims are also much better suited to class actions, which are rare in discrimination cases and have real value to the plaintiff's bar. The statistics seem to bear this trend out. By at least one calculation, in 2019, Massachusetts ranked third nationwide in total cost of Fair Labor Standards Act wage and hour violations per employer. Wage and hour lawsuits nationwide have increased by a staggering 417% in the last 20 years. Now, don't get us wrong, discrimination claims still exist. According to the EEOC, last year, the agency received over 72,000 complaints of workplace discrimination. That's on par with the prior year, but there is a downward trend in overall cases. And Massachusetts accounts for only 0.5% of EEOC charges nationwide. The state with the highest percentage by a significant margin is Texas, with 10.2% of all charges. And Massachusetts is also very low in charges as a percentage of population. Retaliation claims are on the rise and accounted for almost 54% of all charges filed. The top categories of discrimination were disability, race, and sex claims. Religious discrimination accounts for only 3.7% of all charges. And the statistics also show a continuing downward trend in workplace sexual harassment claims. But to our point about the overall decrease in workplace discrimination litigation, there was only about $39 million in monetary benefits resulting from discrimination litigation, which is down from almost $70 million in 2015. So if you're a business owner or an employer, those are some good trends to keep in mind. Keep your eye on the ball when it comes to wage and hour litigation. So that's it from me. I'm going to turn it back over to Max, but if you have any questions about anything at all that I've covered, feel free to contact me directly. Thanks.
Excellent job, Sam. Thank you so much. So if you are or represent a small employer, this is not a good time to take a bathroom break. Stick with me here. And class action considerations. Class actions are not just for the Ubers and Lyfts and Ford Motor Companies of the world. There's no bright line under the law, but the cutoff seems to be if you have 20 employees that are aggrieved by the same policy or action of the company, they can organize into a class action. 20 employees is not that many. So it brings in a lot of employees. So what are we concerned about when it comes to preventing class actions or dealing with class actions? We want to make sure that if we have any any wage and hour policy, whether that's classification of people as independent contractors, classification of employees under the overtime laws, any sort of wage policy that applies to more than 20, we're going to want to make sure that we're hyper vigilant with respect to reviewing that policy for compliance with the wage and hour laws. Because if employees sue on a class action, they sue collectively, they can sue in federal court, they can sue in state court. We're seeing a lot of litigants in state court these days because of a quirk in Massachusetts law, which provides that an employee can bring a class action on behalf of all aggrieved employees. And the individual employees, even if they do not want to be part of the case, do not have the ability to opt out. So this is incredibly disruptive. These are some of the hardest cases to deal with and the most expensive too. Expensive because there's so much procedural wrangling that you're spending money on just the procedure without even getting to the merits. But also because, in particular with respect to wage and hour class actions, there are automatic multiple damages on many of these statutes that apply. And then you multiply that by the number of employees and their damages. So it's high stakes, it's expensive to litigate. So just touch real briefly on this class action issue, but it's something to understand. This is not just going to affect the big employers. This can affect any employer that has 20 or so, or maybe even fewer. I mean, there have been class actions certified with fewer than 20, but you want to make sure that the policies that you have that apply are sound. Let's move on to our last topic, which is trends in non-competition cases. And we can go to the next slide. I think most of us on this call understand that there's a new non-compete, I guess not quite as new, non-compete and trade secret law. They were passed and became effective in October 2018. We have not seen much litigation under these new statutes. We're all craving some guidance from the courts with respect to a few provisions of these statutes, including most prominently this garden leave. So just briefly, the new non-compete law requires that for a non-compete to be enforceable, it has to be supported either by garden leave, meaning you have to pay the employee half of their base pay during the period of restriction, or quote unquote other mutually agreed upon consideration, which is undefined in the statute. And I've had countless conversations with other practitioners who do a lot of non-compete work, and none of us have been able to figure out definitively what that means. I've even talked to judges who decide a lot of these cases, and our opinions on that issue are all over the map. We're hoping and waiting for some guidance, although I fear that even if we get guidance, it's probably not going to be definitive. We'll have a trial court judge who will opine on the adequacy of consideration under the new law. But it won't be binding on the other courts that decide the issue. There is one case that could be read to have an impact on this issue. It's Judge Casper in the federal court decided a case called Nuvasiv. And if you crank your neck and look and bend it in a certain way, you might be able to interpret that case as meaning that ordinary consideration that we've been giving for years and years would be adequate under this new consideration provision. I'm not sure I agree with that, and it takes a couple logic steps, and the decision didn't focus on that issue. So I wouldn't take the new Nuvasiv case as gospel, or I wouldn't hang my hat on it. But we, like I said, we are waiting for guidance. I know there are some legislative efforts right now, none of which I expect will be successful. The legislative term ends on December 31st, and it doesn't seem like any of these bills have gotten any momentum. One of the bills is to eradicate non-competes altogether. I don't think that's going to happen. And another one of the bills is one that would permit the parties to define the term cause, because an employer that terminates an employee under the new statute, an employer that terminates an employee not for cause, can't enforce the non-compete. So we will let you know if there are any cases that come out. If you're on our mailing list, we'll be very quick to announce news. We're eagerly anticipating some sort of guidance that we'll be able to use, not just in litigation, but also to help you all draft your non-competes. Litigation trends. So what we've seen over the last 20 or so years is a de-emphasis on cases involving non-competes and more of an emphasis on cases involving trade secrets. And the trade secret litigation has grown by leaps and bounds. And part of the reason for that is the growth of the Uniform Trade Secrets Act around the country. And Massachusetts in 2018 became the 49th state to adopt the Uniform Trade Secret Act. The lone holdout now is New York. So we've seen, and there's also a federal trade secret law that came into place under President Obama 2015, and the litigation on that statute seems to be growing, kind of doubling every year, at least if you look at reported cases in Westlaw. So we're seeing, I think, fewer non-compete cases, or if it's not fewer non-compete cases, there's not a growth in non-compete cases. There's definitely a growth in trade secret cases and these statutory claims. Talk about the impact of COVID. I've been advising a lot of clients concerning lawsuits in the era of COVID, and what do we do what will the courts tolerate? The courts, and Sam did a roundtable on this a number of months ago, but the courts largely closed to civil matters for a period of time. And if you're going to bring an emergency matter, which a non-compete matter would be, if you're going to bring an emergency matter before the court, it better darn well be an emergency. And I advised a lot of clients in the last, particularly in the spring and summer, that the things that they thought were emergencies, it was very possible that a court would not see it that way. So in the last, I'd say 8 months, particularly in the spring and summer, we resolved a lot of these cases without litigation. I get the sense that litigation is coming back. So to the extent that you're considering filing a non-compete action or restrictive covenant action trade secret case, or potentially having to defend one, I think the courts are much more receptive now than they would have been 5 months ago. So COVID definitely had an impact on the amount of litigation that was being filed, the court's tolerance for emergency matters, but I think that is waning. What happens if there's a second wave that impacts the court's operations is anyone's guess. But if it's like the first wave we had, it will hamper parties' abilities to get into court and deal with these types of cases that the employer will consider an emergency, but perhaps a court would not. So that's our program for today. But be happy to answer that anyone has. And Aaron, maybe you can tell me how the questions would come in. Look at chat. Oh, okay. Looking at chat. Okay, so one question we're getting is, okay, progressive discipline. Understanding the importance of giving the employee ample time to correct their performance or behavior, how long is too long to backfire on the employer? Not holding an employee accountable over a period of years may appear that the performance behavior is tolerated, and a subsequent termination would be a surprise to the employee. The employee now have leverage. Thank you. That's a really good question. So if there is behavior that warrants termination in 2017 and it doesn't it doesn't result in termination, then if you try to terminate in 2020 for the same behavior, that's a problem. The only caveat is if you are giving the employee notice of that performance problem and an opportunity to improve their performance, which is a good idea, and they don't improve their performance over the period of time that you expect them to, then that could serve as ample grounds for termination, and that would be a good sequence for you. But if in 2017 there's a problem, and that same year you say, here's notice of the problem and an opportunity to improve, and they don't improve in 2018 or 19, and then 2020 you say, okay, your performance problem as identified to you in 2017 has not been rectified. let's say in the meantime, the person has developed a disability or had a child. Those, I think it would be a court or jury would look at that and say, well, you know what? It didn't seem like it didn't seem like the employer's priority was that performance issue until they had the child or they had the disability. And I think a court or jury might look at that and be very skeptical as to the employer's reason. Okay, next question. Have you seen any 28 claims in regards to COVID? Sam, do you want to take that one?
I'd like to. I'm not totally certain that I'm not totally.
Let me go to the next question, and the person who wrote that in, maybe you can be a little more specific as to what you're asking. Let me ask the next question. So, any guidance regarding how best to establish, document, and evaluate performance during a new employee's probationary period? I guess I would not distinguish between documenting and evaluating performance during a probationary period as opposed to during a non-probationary period. I was going to say permanent employment, but Kathy would have zapped me with the electrodes she's got around my neck if I said permanent anything. So no, I think that if you have a probationary period, certainly that is a time where your evaluation of the employee is heightened, and maybe what you do is instead of having an annual performance check, you actually check in more frequently and have some documentation that comes out every month. So let's say the probationary period is 3 months. So you've got every 2 weeks or every month, there is an evaluation that would be documented that if at the end of the probationary period, the company decided not to proceed with employment, you'd give me the opportunity to put in evidence of the performance, the legitimate reasons why the employer decided to discontinue. Okay, so we've got a little more clarity. Sam, can you see the? Can you see the?
Yeah, I can. So, so Leah, to answer your question, to my knowledge, at HRW, we have not seen that sort of a claim. But that doesn't mean they're not happening. I haven't seen a claim like that in the courts, but as I alluded to, I think we should anticipate those sorts of claims. But as I also mentioned, I think a lot of litigators are skeptical about the viability of those claims because causation is going to be, a pretty difficult thing to establish. So maybe that might account for the plaintiff's bar not having sort of latched on to that line of attack quite yet. Max, anything to add there?
No, except to say that we have a COVID team that is par excellence. They are on top of all the developments. They've done a great job in advising clients in real time how to deal with the new regulations and developments that have come out. Have put out some utterly fantastic materials. I know Kathleen Burney was one of the drivers in putting out materials on return to work and a toolkit on how to return to work safely in the era of COVID. So understand that those materials are available to clients, and we're going to be updating that. So if there are claims the claims that Sam has anticipated and forecasted, we're going to be covering those. And you'll see those in our client alerts. You'll also see those in future roundtables. I would imagine, although Kathy Rubin is the roundtable czar, she will, I'm sure, be putting on a COVID presentation at some point in the 2020 year as necessary and as things develop. Are there any more questions?
I'll just clarify. There was some chatter in the chat about questions about the materials we've been referencing, and just to clarify, those are going to be provided as a follow-up here in a day or so. Is that right, Max?
I think maybe even later today. So yeah, and you'll see an article by me about conflict avoidance and how it hurts. You'll see an article by Scott Roberts about things you should do in the immediate aftermath of being served with a lawsuit. So I think that's a good thing to keep handy. You might also take the 3 slides from the playbook and laminate those and put them in your desk drawer, just in case you get a summons and complaint. And you also see the transcript from the witness who failed to preserve evidence properly, where I think my last line was, would somebody please call 911, which is on the transcript. So I think that concludes us for the day. I'm not seeing any further questions, and we really appreciate really appreciate everybody coming, and stay tuned for future roundtables, and we look forward to seeing you there too. Thanks so much.
Thank you.